All right, good afternoon, everyone. Let's call the case of Ethel Marks versus Sunny's Rooftop Bar to order. We'll begin by having the parties state their appearances for the record, beginning with the plaintiff.
Good afternoon, Your Honor, members of the jury. My name is Lucy Bolter, and today I represent Ethel Marks in the memory of Jessica Marks. Today, I'll be joined by my co-counsel, Lauren Nonemacher.
Good afternoon, Your Honor.
Good afternoon. Thank you very much, plaintiff counsel. Defense.
Good afternoon, Your Honor. My name is Lauren Mukavitz, and today I, along with my second chair, Ms. Kira Lentz, will be representing the defendant in today's case, Sunny's Rooftop Bar. Ms. Lentz will be serving as my second chair, and she will be helping me with all of the exhibits and technology in today's case. Her audio and video will remain off for the duration of today's trial.
All right, thank you very much, defense counsel. All right, before we proceed with opening statements, plaintiff, do you have any preliminary matters that you want to attend to?
Yes, Your Honor. We would just like to draw the court's attention to the evidentiary rulings found on pages 7 and 8 of the electronic copy of the case, specifically rulings 11 and 13.
All right, go ahead. You can pull those up.
Ruling 11 is that exhibits 1, 22, and 23 are pre-admitted and may be used at any time. And ruling number 13, at all times relevant, Frankfurt Johnson and Sunny Meadow were acting on behalf of the defendant, Sunny's Rooftop Bar. And with that, Your Honor, the plaintiff is ready to proceed to opening statements.
All right, I have reviewed the pretrial order. I understand that those have been made by our pretrial judge. So thank you. The court will note those. Ms. Mukavitz, anything from you?
Yes, Your Honor. We move to invoke rules 603 and 615 to constructively swear in all witnesses and sequester witnesses, save party representatives.
All right, would you like to designate a party representative on behalf of the defense?
Yes, Your Honor. We'd like to designate Sunny Mehta as our party representative.
Okay, plaintiff, any objections to either of those or the designation of Ms. Mehta as the party rep?
No, Your Honor.
Okay, great. So all witnesses will be presumed sworn when they take the stand to testify, and all witnesses will be excluded constructively from the courtroom except for Ms. Mehta.
Your Honor, may we assume that exhibits that have yet to be admitted are shown constructively outside the presence of the jury?
Yes, I'm fine with that given the format and for efficiency purposes, absolutely. We'll assume that why don't we just say that they're constructively published to the jury? We don't need to ask for that once they're admitted in evidence.
And finally, Your Honor, we'd like to ask a brief clarification question. Point 8 of the pretrial order states that once exhibits are admitted, counsel performing an opening, examination, or closing may display such exhibits on screen at any time without specifically requesting permission. However, we'd like to know your preference as regards to exhibits before they're admitted. Would you like us to request permission before sharing, or would you like us to simply share them?
Yeah, that's fine. I appreciate you asking. Why don't you just note on the record that you are showing it to the witness? You can display it on the screen, but again, as per your request, and I agree with this makes sense, we'll assume it's constructively outside the view of the jury until it's been admitted, but no need to ask, just note it for the record.
Yes, Your Honor, and with that, the defense is ready to proceed.
All right, thank you very much. And with that, Ms. Bolter, you may proceed with your opening statement. And I'm just going to note here very quickly before you do, just as a reminder to everyone, let's put this change of view to speaker view so that way we can see both lawyers presenting their statements in full screen. All right, go ahead, Ms. Bolter, whenever you're ready.
May it please the court, counsel, members of the jury. Failing to check is failing to protect. At least that's the case when it comes to bars serving alcohol to minors. Jessica Marks was a young girl who had her entire life ahead of her. But on March 24th, 2019, she took her last breath. She didn't get to say goodbye to her mom. She didn't get to finish her college classes. She didn't even get to board her flight home. Because on that night, the defendant in this courtroom today failed to do her job. She failed to protect Jessica Marks, and that young girl is dead because of it. Today, I represent the memory of Jessica Marks, that 19-year-old girl that woke up on that Sunday morning excited to spend the last day of her spring break with her best friend, Morgan Levin. They planned to visit the California beaches, post pictures on their Instagram, and return home tan and relaxed. But what she didn't know was that morning would be the last time Jessica Marks would ever see the sunrise. That night, Jessica and her friend Morgan walked into Sunny's rooftop bar, found a cool table, and began ordering drinks. But the bar owner, their server that night, didn't even bother to check their IDs. Now we all know minors aren't supposed to drink alcohol. But the truth is, young people sometimes make really poor choices. The Dram Shop Act places the responsibility on bar owners to be certain that they're not serving alcohol to minors, especially ones showing signs of obvious intoxication. But that night, this defendant failed to do what the law required. This defendant failed to check IDs, failed to notice those signs of obvious intoxication, and failed to protect Jessica Marks from getting behind the wheel of a car after serving her over $100 worth of alcohol. Now, this judge is going to tell you that we, the plaintiff, have sued Sunny's Rooftop Bar for the wrongful death of Jessica Marks. Because of that, we carry what is called the burden of proof. That simply means it's our job to prove to you, just by the greater weight of the evidence, that this defendant continued to serve Jessica Marks, a minor, when she was obviously intoxicated. Now, we'll only need to bring you just one witness to meet that burden: Morgan Levin, the one that was with Jessica that night, the one that drank with her, and the one that videotaped her. She'll tell you just how many drinks this defendant served Jessica, and she's even going to tell you what this defendant said as she saw Jessica stumbling because she was so drunk. But you're not just going to hear that from Morgan Levin. You're actually going to get to see it for yourself. Photos and videos of Jessica from that night. You'll see how obviously intoxicated she was, while this defendant continued to serve her drink after drink. At the end of this trial, I'll come back before you and ask you to hold this defendant responsible for the death of Jessica Marks when she failed to check and failed to protect. She violated that law, so I'm going to ask you for the only just verdict in this case: finding her liable. Thank you.
Thank you very much, Ms. Bolter. Ms. Mukavitz? All right, you're on screen and you can proceed whenever you're ready.
Yes, Your Honor. Your Honor, Ms. Bolter, members of the jury. Deadly decisions. Ms. Bolter, she just told you a lot about something that happened 2 years ago at Sunny's Rooftop Bar. But she didn't tell you about the deadly decisions made that day. And she didn't tell you that the deadliest decision made that day was made by Jessica Marks herself. Now, we are not saying that her death wasn't a tragedy. It was. She was 19 and she had her whole life ahead of her. And our hearts and condolences go out to her family and friends. But we are here today to discuss her death. And we can't do that without also discussing the decisions that she made that day. So let's do that. Let's go back to March 24th of 2019. Jessica Marks is 19 years old. She's a freshman at Drexel University, and she's here in LA visiting her childhood best friend, Morgan Levin. It's her last day here, and she wants to make the most of it. So the two of them, they go to Sunny's Rooftop Bar. They get there around 9 p.m. They get a seat up on the roof, and Sunny Mehta, the owner, was actually the one to take their orders. Now today, you'll hear from Miss Mehta. Miss Mehta will tell you that she interacted with Miss Marks at least 8 times that night. And in none of those interactions did Miss Marks at all appear obviously intoxicated. But you'll also hear that at the end of the night, Miss Marks had a decision to make. She had been drinking and she had to decide whether or not to get behind the wheel and drive. That night, she was told that it might not be safe for her to get behind the wheel, and there was an Uber in the parking lot. But members of the jury, Jessica Marks, she made the decision to get into her car and to pull out of that parking lot. And that decision, it proved itself deadly. Now today, the plaintiff has the burden of proof. They have to prove to you by a preponderance of the evidence that Sunny's rooftop bar served Jessica Marks when she was 19 years old and clearly intoxicated. But today, we as the defense have raised an affirmative defense of comparative fault, which means that we also have a burden of proof. We have to prove to you by that same preponderance of the evidence, and we will prove to you that it was more likely true than not that it was Jessica Marks's own deadly decisions and negligence that caused her death, and not Sunny's rooftop bar over serving her. And we know that this is uncomfortable. We know that analyzing and scrutinizing the actions of someone who has passed away is uncomfortable. But members of the jury, today you took an oath to follow the law. And decisions in a court of law, they are not made based upon sympathy or prejudice. They're made because they're based in evidence. And today, the evidence will show that Miss Marks made decisions that caused her death, which is why at the end of today's trial, I will come back before you. And I will ask that you find Sunny's rooftop bar not liable. And if you find that they bear any of the responsibility for the events of March 24th, 2019, that you ask yourselves, who really made the decisions that cost Jessica Marks her life? Thank you.
Thank you very much, Ms. Mukavitz. Before we proceed to the presentation of evidence, let's just have everyone change their view back to gallery view so we can see all of our attorneys and witnesses when they're presenting. And with that, I'm going to turn it back over to the plaintiff. As I see, there you are, you're on screen, Ms. Bolter. Okay. And there's defense counsel. Okay, great. Ms. Bolter, you can call your first witness.
The plaintiff calls Morgan Levin to the stand.
All right. Morgan Levin is on screen and you are presumed sworn. You can proceed whenever you're ready.
Before I begin, Ms. Levin, I just want to make sure that you can hear me okay.
Yeah, I can.
Please introduce yourself.
Hi, my name is Morgan Levin.
Ms. Levin, where do you currently live?
I live here in California. I'm a student at UCLA.
Ms. Levin, I want to talk about the reason we're in court today, the night of March 24th. Do you remember that day?
I'll never forget it.
What were you doing that day?
Well, my best friend, Jessica Marks, she was down from Philly visiting me in California. She had an Airbnb, and that day she had picked me up to come hang out. And then we went to this bar called Sunny's Rooftop Bar.
How did you get to the bar?
Well, Jessica was the one with the rental car, so she drove us.
Did you have any concerns about her driving you to the bar?
No, I don't remember having any concerns. She seemed perfectly fine to me.
Could you describe that bar to us?
Yeah, it was kind of cool. I heard that it was recommended, so that's why we went there. When you first get there, there's this like giant staircase that goes up, and there's this rooftop seating kind of that overlooks the ocean and the mountains, and we were seated up there.
What did you order that night?
I started with a glass of wine. We got some chips and guacamole.
Would you recognize a receipt of what you had at the bar that night if I showed it to you today?
Yeah, I would.
Your Honor, may the record reflect that I'm showing this witness what's been pre-marked as Exhibit 17 for evidence.
The record will so reflect.
Ms. Levin, do you recognize what this is?
Yeah, it's the receipt from that night. You can see my signature right there at the bottom.
And is it a fair and accurate depiction of the receipt that you got that night on March 24th, 2019?
Yeah, it was.
Your Honor, at this time, the plaintiff offers into evidence Exhibit 17 as Plaintiff 17.
With no objection, Your Honor.
All right, Exhibit 17 will be admitted.
Ms. Levin, what on this receipt do you specifically remember Jessica drinking?
Well, I mean, I had one glass of the red wine, one of the beers, and a tea shot. Jessica had everything else.
So all of those drinks that you just mentioned Were they alcoholic?
Yeah, all of the drinks on the receipt were alcohol.
Did you actually witness Jessica ordering her drinks herself?
Yeah, we were both ordering from Sunny Meta, the bar owner.
Now, Miss Levin, did you take any pictures or videos at the bar that night?
I did. I have this Yelp account and I like to post pictures from places that I go. So I took some pictures for the account that night.
Would you recognize those pictures if I showed them to you today?
Yeah, I would.
May the record reflect I'm showing this witness what's been pre-marked as exhibits 11 through 16.
Yes, it will so reflect.
Miss Levin, do you recognize these pictures?
Yeah, these are all pictures that I took from my phone that night.
And are they a fair and accurate depiction of the photos that you yourself took on the night of March 24th, 2019?
Yeah, they all are.
Your Honor, at this time, the plaintiff offers into evidence a composite exhibit of exhibits 11 through 16.
Without objection.
All right, this composite exhibit is received.
Miss Levin, what time frame were these pictures taken?
I think that Exhibit 11 was taken probably 9:10, and Exhibit 16, I think I remember taking it at 11:30. I also remember taking a video.
You just mentioned a video that you took at the bar. Is this it?
Yeah, from the front view that I can see right now, it looks like the video that I took of Jessica.
And from what you can tell, is it a fair and accurate depiction of the video that you yourself took that night?
Yes, it does.
Your Honor, at this time, the plaintiff offers into evidence Exhibit 10.
Any objection to this?
Yes, Your Honor, we object to hearsay.
All right, as to what specifically, counsel?
Specifically at the end of the video, Miss Marks, she makes a comment saying, "Go hard or go home," and we are objecting to that statement as it does go to prove the truth of the matter asserted.
All right, response, Ms. Bolter?
Yes, Your Honor, we'd be happy to redact that specific statement.
Okay, with that understanding, defense counsel, are you amenable to the rest of the exhibit being admitted?
Yes, Your Honor.
All right, sounds good. So it's my understanding, and I've watched this video in camera, so why don't we just stop the video before it gets to that statement? Is that possible if we can arrange that with plaintiff's counsel and plaintiff's co-counsel?
Yes, Your Honor.
Okay, great, sounds good if you intend to play it. All right, go ahead.
Ms. Nonnemarker, could you play that video for us?
Hi everyone, Morgan and I are in Hollywood. We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well.
Miss Levin, is that how your friend Jessica Marks normally acts?
No, I don't think I've ever seen her that way before. She never slurs her words like that. Her eyes were red. She smelled like alcohol.
At any point that evening, did you see Jessica lose her balance?
Yeah, that night I can't remember what round it was after, but we were coming down the bar stairs to go to the restroom, and Sunny Meta she was walking up the stairs, and Jessica lost her balance and stumbled into her. And then after that happened, because we were on the stairs and down below is like the floor bar, I guess you could say. Sunny then said to Frankfurt, the bartender, and said, "We might have to cut this one off."
Miss Levin, did Jessica make it home that night?
No, she didn't. When we left the bar, I had ordered an Uber to come pick us up, but Jessica's flight was the next day, so she didn't want to leave the rental car in the parking lot, and so she got in her car and she started to drive. And I just remember seeing her pull onto the highway, and I was right behind her, and then her car just drove across the side of the freeway, and she was dead.
Thank you, Ms. Levin. I have nothing further.
Thank you very much, Ms. Bolter. Ms. Mukavitz, cross-examination.
Yes, Your Honor.
Whenever you're ready, go ahead.
Ms. Levin, you were underage on March 24th, 2019, correct?
Underage, meaning that I wasn't 21?
Yes, you were a minor.
Yeah, I was 19.
And in your visit with Miss Marks, the two of you consumed alcohol, correct?
Yeah, we did.
In order to consume alcohol, the two of you had fake IDs.
Yeah, when Jessica came from Philly, she had brought 2 fake IDs, and she told me that mine was my, early 21st birthday present.
Your Honor, let the record reflect I'm showing Miss Levin what has been previously marked as Exhibits 3 and 4. Miss Levin, these are the IDs that Miss Marks brought, correct?
Yeah, that looks right to me from what I can recall from that day.
They're fair and accurate copies of those IDs?
Yeah.
Your Honor, at this time, the defense moves Exhibits 3 and 4 into evidence.
Any objection?
No objection.
All right, exhibits 3 and 4 are admitted.
Now, Ms. Levin, you had these IDs with you on March 24th, 2019, correct?
I just had mine. Jessica had hers.
But you both had them in your possessions?
Yeah, we did.
But you didn't just have those IDs at Sunny's Rooftop Bar, did you?
No, like I said, she got them from Philly, and she was out in California for the week. We did a couple things over the week, and we used them then.
On Monday, Ms. Levin, you went to Anna's Grilled Cheese, didn't you?
Yeah, we did. I remember laughing at how funny that name was to me.
And on Tuesday, you went to Toby's Taps.
Yeah, that sounds right.
On Wednesday, you went to 2 places, didn't you?
From my memory of 2 years ago, yeah, I think we did.
You went to Disneyland's California Adventure.
Yes.
And you went to Harper's?
Yeah.
On Friday, you went to a wine bar called Cher?
Yeah, we did. It was a high-end wine bar, and we felt really official and really grown-up going.
And on Saturday, Miss Levin, you and Miss Marks, you went bar hopping in Westwood?
Yeah, that was all on foot. We walked from bar to bar. Probably one of my favorite memories of that trip.
Now, Miss Levin, you or Miss Marks, either of you used those IDs at least once at all of the places that I mentioned?
Yes, that's what I remember.
And all of the places that I just mentioned, they asked to see those IDs, didn't they?
Yeah, they did. They always check the IDs before they ordered or give us any drinks.
And none of those places refused to serve you?
No, none of them did.
And in order to get to and from these places, Miss Levin, Miss Marks drove, didn't she?
Yeah, she did. She got a rental car at the airport, and I didn't have a vehicle at the time because I was living in the dorms. So all of the week we were in Jessica's car.
And she drove even after using her fake ID?
Yeah, she did.
She drove even after drinking?
Yeah, I think each time that we would go someplace, we'd each have maybe one, at the most 2 glasses of alcohol. And then, yeah, Jessica would take the rental car.
Now, Ms. Levin, let's talk a little bit about March 24th, 2019. That night, you started off with Jessica Marks at her Airbnb, correct?
Yeah, that's, she picked me up took her to the Airbnb.
And in order to get to Sunny's rooftop bar, Miss Marks drove you.
Yeah, she did.
But at the end of the night, Miss Levin, you didn't want to get back in that car, did you?
No. When I saw Jessica, she was slurring her words, her eyes were red, she was falling down the stairs. I didn't think that she was safe to drive.
So you ordered an Uber?
Yeah, I ordered an Uber.
And you told Miss Marks that you didn't feel safe getting in a car with her, didn't you?
Yeah, I did. I tried to convince her to take the Uber with me, but her flight was the next day and she didn't want to leave the rental car like 40 minutes away from her Airbnb.
That's right, Miss Levin, you asked her to get into the Uber.
Yeah, I did.
But she told you, I've gotten pretty good at driving after a big night, didn't she?
Objection, hearsay.
Your Honor, may I respond?
Yes.
Your Honor, although this statement is hearsay, it falls under the exception 8033 for the then existing mental, emotional, or physical state. This statement by Jessica Marks that I've gotten pretty good at driving after a big night, it lays out her intent and her plan to drive after drinking. And in the context of which it is said, it lays out the fact that she believed that she had some increased physical or mental capacity that allowed her to drive even after drinking.
Plaintiff, would you like to respond on those grounds?
Yes, Your Honor. There is no context or guessing about her statement. We don't know if she was joking. We don't know if what she was thinking at that time. Therefore, it can't be used to show her intent or her plan without showing what she was actually thinking. And this is just speculative. We don't know what the context was with it.
All right, any last word from the defense?
Yes, Your Honor, briefly. Your Honor, there was context to this conversation. Miss Levin just testified that she asked Jessica Marks to get into the car, the Uber that was in the parking lot, because she didn't feel safe driving with Jessica because she thought that Jessica looked drunk. And in that context, that is when Miss Marks responded with, I've gotten pretty good at driving after a big night.
Okay, well, based on those representations, I'm going to admit it. And I want to note at least that plaintiff, your arguments are well taken, but those are matters of weight, and I would encourage you to cross-examine on them. But when we're just assessing whether hearsay satisfies that exception, we look at the words themselves. Whether you think that they might not have meant it, those are matters of weight, so you can redirect on those issues if you think that she didn't actually mean it. But as so far as the words themselves, if evidence some sort of intent based on the arguments before the court, I will admit it on that basis.
Yes, Your Honor.
Miss Levin, in response to you asking her to get into the Uber, Miss Marks told you, I've gotten pretty good at driving after a big night, correct?
Yeah.
And she made the decision to get into her car?
I mean, yeah, she got into her car.
Now, Miss Levin, you are aware that Mrs. Ethel Marks was planning on suing you as well, correct?
When she first arrived at the scene, Jessica's car had crashed, she was really emotional and really angry, and I was too. And yeah, she threatened to sue me, but she's not.
But now, Miss Levin, you're actually testifying for the plaintiff, aren't you?
Ma'am, I'm just here to tell the truth. I'm not testifying for anyone.
Miss Levin, that wasn't my question. You're testifying for the plaintiff, aren't you?
Well, my directing attorney, she is a representative of the plaintiff, so I mean, I guess you could say that.
Thank you, Your Honor. I have no further questions.
Thank you, Ms. Mukavitz. Ms. Bolter, any redirect examination for this witness?
Yes, briefly, Your Honor.
Go ahead.
Ms. Levin, the attorney just asked you a lot of questions about a fake ID that you might have had that night. But were you ever asked about an ID while you were at Sunny's rooftop bar?
Objection, Your Honor, goes outside the scope of cross-examination.
Okay, how so?
Your Honor, on cross-examination, I asked Miss Levin if she used it at the places that I named. However, I never named Sunny's Rooftop Bar.
All right, Ms. Bolter, response?
Yes, Your Honor. Ms. Mukavitz said many places where she used a fake ID, accused Ms. Levin of using a fake ID, and then asked her about a night of Sunny's Rooftop Bar, entering the bar, leaving the bar. This doesn't go outside of the scope of the cross-examination.
I agree. I think it's close enough where you did elicit a substantial line of questioning related to her use of one of those fake IDs at other restaurants and locales around Los Angeles. So I think it's relevant to see if she used it in this case, since this is in fact the incident that we really care about here. So based on that line of questioning on direct or on cross-examination, I'll allow that redirect question here.
Ms. Levin, do you need me to repeat that question?
No, I remember. I don't remember ever showing an ID or being asked for any of our IDs at Sunny's.
Thank you, Ms. Levin. I have nothing further.
All right, any recross examination from the defense?
No, Your Honor.
Okay, then Ms. Bolter, may this witness be excused?
Yes, Your Honor.
All right, thank you very much for your testimony, Ms. Levin. You may be excused.
And Your Honor, trying to rest our case in chief, pursuant to the evidentiary rulings found on pages 7 and 8, we wish to read 2 small excerpts from evidence that have already been admitted at this time.
All right, can you direct us to which exhibit that is? These are one of the
Yes,
previous
Your Honor.
exhibits, I assume?
Exhibit 1,
Okay.
the plea agreement, and then Exhibit 23, the accident report.
All right, that's fine. Those are, it's my understanding, defense, correct me if I'm wrong, those are among the exhibits that were admitted by our pretrial judge. Is that right?
That is correct, Your Honor.
All right, so then Ms. Bolter, go ahead. You can read those. I'll note for our procedural and local rules, this is coming out of your direct examination time. So go ahead.
Yes, Your Honor. The defendant, Sunny's Rooftop Bar, agrees to purchase and utilize an identification scanner when furnishing alcohol to its customers believed to be 35 years of age or younger. And then the accident report. Blood had been drawn at the scene of the accident and indicated that Marx's BAC at the time of the crash was 0.16. In California, it's illegal to drive with a BAC of 0.08 and illegal for someone younger than 21 to drive with a BAC of 0.01. It's also illegal to serve someone alcohol if they are younger than 21. I spoke to Sunny Mehta, the bar owner. Sunny said that Jessica Marks was a typical buzzed girl. I asked Sunny and Frankfurt why they never purchased an ID scanner as they agreed to do in 2018. Sunny said that they did purchase one, but it was broken a few weeks prior. And with that, Your Honor, the plaintiff rests its case.
All right, thank you very much. With that, defense, any witnesses or evidence to present?
Yes, Your Honor. The defense calls Sunny Mehta.
All right, Ms. Mehta is on screen. Both parties are still present, and Ms. Mukavitz, whenever you're ready, you may proceed.
Good afternoon, Ms. Mehta. Please introduce yourself to the court.
Good afternoon. My name is Sunny Mehta.
Ms. Mehta, what do you do for a living?
I used to own and run a bar and restaurant in Malibu, California called Sunny's Rooftop Bar, but I sold it earlier this year, and now I'm looking to invest in another business in the area.
Did you need any certifications to open Sunny's?
Yes, I did. I had to obtain a California business license. It regulates how to run a restaurant. And I also had to get a liquor license for the area, which regulates the serving and keeping alcohol on the premises.
Did you need to take any courses in order to obtain those certifications?
Yes, ma'am. First, for the business one, that focused mostly on the restaurant aspect, keeping food at a proper temperature, things like that. The liquor license training course focused on looking out to see when people had had too much to drink, and it also taught you when you should stop serving alcohol or when you shouldn't serve alcohol.
When were you taught to stop serving alcohol?
The primary one is when people are displaying those signs of intoxication that we were trained to look for.
What signs of intoxication were you trained to look for?
There's a few. There's first the physical ones, what you can see, that would be bloodshot eyes or a vacant gaze. And then there's more ones you have to notice on your own, like slurred words or speech, if people are speaking incoherently. And then there's also if there's a lack of coordination, that can all indicate intoxication.
Now, Ms. Mehta, I want to talk to you about March 24th, 2019. Do you remember that day?
Yes, ma'am, I do.
Were you working at your bar that night?
Yes, I was. I was working as a server upstairs.
Was anyone else working with you?
We had a bartender who was working downstairs making the drinks, Frankfurt Johnson.
And that night, Ms. Mehta, did a woman named Jessica Marks walk into your bar?
Yes, she did. We had her upstairs in the rooftop bar at table 4.
Was anyone with her?
Yes, ma'am. She was with a friend, Morgan Levin.
And before Morgan Levin and Jessica Marks entered your bar, had you ever met them before?
No, I hadn't.
Now, Ms. Mehta, do you remember who served Ms. Marks and Ms. Levin that night?
That was me. I was the only server working that night.
Did you take their orders as well?
I did.
Since you took both their orders and you served them their drinks, Ms. Mehta, about how many times would you say you interacted with Ms. Marks?
I would say probably between 8 to 10 times. I took their orders, maybe 4 or 5, and then I had to bring them drinks for every order. So probably 8 to 10.
And about how long would you say those interactions lasted?
Probably around a minute. I like to speak with the customers, interact with them, make sure they're doing okay. So I'll drop off drinks and have a short conversation with them before I move on to the next table.
Ms. Mehta, did Ms. Marks appear at all obviously intoxicated in any of those interactions?
No, to me, she wasn't displaying those signs of intoxication.
Ms. Mehta, do you remember what time Ms. Marks and Ms. Levin left your bar?
I believe it was a little after 11:40, maybe 11:45.
And do you remember discussing with them how they got home?
I did.
Did you know that Ms. Marks was planning on driving herself home?
Yes, I did. I spoke with them. I wanted to make sure that Morgan Levin wouldn't be driving because she seemed to be more on the intoxicated side. Ms. Marks informed me that she had decided to drive home, and then they left.
When you heard this, were you at all concerned about Ms. Marks' well-being?
No, the only point of concern is if they're displaying signs of intoxication, that's when we stop them and make sure they have another way home. But since Ms. Marks wasn't displaying those signs, we didn't have a reason to find an alternate way home.
Ms. Mehta, I want to address something that happened earlier today in trial. Were you here for the duration of today's trial so far?
Yes, I've been here the whole time.
And were you here for Morgan Levin's testimony?
Yes, ma'am, I was.
Did you hear when Morgan Levin stated that Jessica Marks fell down the stairs?
I did hear her say that.
Did that ever happen?
No, it didn't. I saw them come down the stairs as they were leaving, but they walked down fine, no stumbling. We didn't speak. I just made sure they were okay to leave.
And Ms. Mehta, were you at all watching them when they walked down those stairs?
Yes, I was. I watch the customers as they're coming down the stairs, especially before they're leaving, to make sure we don't have to make arrangements for them to get home if they're displaying signs of intoxication. But that wasn't happening that night, so we didn't make those arrangements.
And when you saw Ms. Marks go down those stairs, did she seem intoxicated to you?
No, ma'am, she didn't.
Did she stumble or lose her balance?
No, ma'am, she didn't.
At any point during the night, Ms. Mehta, did you feel the need to take her keys?
No, we only do that if someone's displaying those signs.
At any point, did you feel the need to call her an Uber?
No.
And Ms. Mehta, at any point during the night, did you feel the need to cut Jessica Marks off?
No, we only do that if they're displaying signs of obvious intoxication, and that wasn't happening with her that night.
Thank you, Your Honor. I have no further questions.
Thank you very much. Ms. Bolter, cross-examination?
Yes, Your Honor.
All right, whenever you're ready.
Before I begin, Ms. Mehta, I just want to make sure that you can hear me okay.
Yes, I can.
As the bar owner, you're required to receive training, right?
Yes, that's correct.
Part of that training was about spotting fake IDs.
Yes, that's correct.
The bar was required to have a scanner to verify IDs.
Yes, that's correct.
Now, on March 24th, 2019, you saw Jessica Marks walk into your bar.
Yes, I did.
You did not use the scanner to check her ID.
Oh, we couldn't. It broke a few weeks ago. We were waiting for our shipment to come in from Amazon with the new one. So the bartender and I were checking IDs by hand that night.
So because the machine was broken, you were left to check it manually.
Yes, we checked them by hand.
But the truth is, you did not ask for her ID when she first came in.
No, our policy is we ask for their IDs when we first serve them alcohol, because we're a restaurant and a bar. Some people don't order anything. So when she first walked in, she hadn't ordered any alcohol, so we didn't card her then.
Well, Miss Mehta, you don't even have a specific memory of ever looking at any ID for Jessica Marks that night.
I don't specifically recall, but it's policy that we card everyone, so I'm sure I must have.
Well, after her death, you were shown her ID.
I was shown a picture of one of her IDs, yeah.
And within just a second, you could tell that it was clearly a fake ID.
That's correct. What they showed me was clearly a fake. I'm not sure if that's what Jessica showed me.
Well, not only was it a fake, but it was a bad fake, right?
That's correct. It didn't have the hologram in the corner, and it was missing her height.
Now that night, you were short-staffed.
We only have 2 people working on Sundays because it's usually a slow night, yes.
Well, there were at least 20 people in the bar that night, right?
Yes, that's correct. That's why we have someone making all those drinks. The other person is more of a runner and a server. That was me.
That night, you were the one that took orders to Jessica's table, table 4.
Yes, I did.
This is the receipt of table 4.
Yes, it is.
You took decoy red blend to her table.
Yes, I did.
You took 3 White Claw cans to her table.
Yes, ma'am.
You took an IPA draft to her table.
Yes, I did.
You took Sierra beers to her table.
Yes, I did.
You were the one who took the green tea shots to her table.
Yes, I was.
Just to be clear, those shots weren't actually tea, they're hard liquor.
It's a mixture of whiskey, peach snaps, those are the liquor, and then there's also the sour solution and some Sprite in there as well.
Each of those shots has more than 55% alcohol, right?
Yes, there's about 2 ounces of alcohol in the shot glass. The rest is the other 2 mixtures.
Miss Mehta, not only did you take the alcohol to Jessica Marks, you were actually the one that removed the empty glasses and bottles from her?
Yes, I was the one bringing drinks and clearing them from the table.
So you could tell that the alcohol had been consumed.
Yes, I can't specifically remember if the drinks were fully finished. I assumed they were, or I wouldn't have cleared the drinks.
Now, you took Jessica Marks's order at least 8 to 10 times?
4 to 5. I was there 8 to 10, taking orders 4 or 5, bringing the drinks the other 4 to 5.
Well, each of those times you actually saw and spoke to her up close.
Yes, I did.
So let's listen to how Jessica actually sounded as she spoke to you. Miss Nonamacher, could you play that video for us?
Hi everyone, Morgan and I are in Hollywood. We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay.
Now, Miss Mehta, that is Jessica Marks.
That's Jessica Marks, yes.
That's the girl that you kept serving alcohol to on March 24th.
That's her, but she didn't sound like that when I spoke with her.
Miss Mehta, you've actually been convicted of a crime involving dishonesty before.
Yes, there was an issue with the TV that was stolen property a few years ago.
Objection, Your Honor, 404B.
All right, go ahead and explain.
Yes, Your Honor, this is a prior bad act. Your Honor, may I change my objection to 403?
Sure. Okay. Okay.
Your Honor, this act by Mr. Mehta having previously stolen a TV, that is substantially more prejudicial than it is probative. This is a prior act that has nothing to do with today's case, and therefore it runs the substantial risk of prejudicing the jury against Ms. Mehta.
All right. Response from the plaintiff.
Yes, Your Honor. A witness's credibility is always relevant as it is used for the jury to determine how much weight they should give to their testimony. The fact that she has been convicted of a crime involving a false statement or dishonesty is extremely relevant and is necessary for the jury to hear to determine how much weight they give to this witness that's testifying today.
Your Honor, may I respond on those grounds?
Sure.
Your Honor, pursuant to the pretrial order number 24, it states that Section 496 of the California Penal Code states, in relevant part, every person who buys or receives any property that has been stolen or that has been obtained in any manner constituting theft or extortion, knowing the property to be so stolen or obtained, or who conceals and sells, withholds, or aids in concealing, selling, or withholding any property from the owner, knowing that the property to be so stolen or obtained shall be punished by imprisonment in a county jail for no more than 1 year, or imprisonment pursuant to subdivision H of section 117. There is nothing in this point that states that this is a crime of dishonesty. Additionally, Your Honor, under Rule 609, impeachments by criminal conviction cannot happen unless the punishment in the convicting county is for more than 1 year. And point 24 of the pretrial order states that it should not be punished by more than 1 year.
Your Honor, may I respond on those grounds?
All right, let's narrow this really quickly. So we're under 609 here. We're asking whether this satisfies as this prior conviction is admissible to impeach the witness's credibility. I'll start by saying yes. I'm familiar with California Penal Code Section 496. It is up to 1 year, not exceeding 1 year. So this is not going to fall under at least that provision of the code. But the question remains: is it a crimen falsi? Is it an act for which the court had to make a finding of an act of dishonesty or making of a false statement? So I'm going to just narrow it and say that's the last issue we have to take care of here. So go ahead with that narrowing of the scope of the issues. Go ahead, Ms. Bolter.
Yes, Your Honor. This witness was in possession of an item of $3,000, which is involving the identity of theft and dishonesty and false statement. Therefore, it does fall under that exception.
Okay, how do you respond to Ms. Mukavitz's point about the language of the code itself? It's her position, of course, that it doesn't involve, that at least the language of the code and the language of the conviction doesn't require at least any action of dishonesty or making of a false statement. How do you respond to that?
Yes, Your Honor. The crime itself, theft, is a false statement, but also the theft itself was $3,000, which makes it a felony conviction where it doesn't fall under that category.
Hold on.
Your Honor, may I respond?
Hold on, let me clarify one thing first. So can you point me to, so it's your position, let me make this clear. We have two ways we can try to get this in. We can try to get it in as a false statement, or we can try to get it in as a felony conviction for which there's a year or more in prison. Which way are you trying to go?
A felony conviction as it's $3,000, the felony amount. I'd be happy to point to you in her deposition where it does say that specific amount.
Okay, I don't question the amount there. I'm questioning whether this satisfies the prongs of 609. And so if we're going to look at the language of the conviction in California, in the California Penal Code 496, we have to see something that shows that it satisfies what 609 requires for at least this jurisdiction. So it's your position that it seems clear that the language of 496 says up to 1 year in prison, not exceeding or not 1 year exactly or exceeding a year. So how do you respond to that point?
Well, Your Honor, felony would be more than a year, but this specific price amount makes it a felony charge.
Okay, let me pull up the code.
Yes, Your Honor.
So I can see and clarify this because I want to make sure we get this right. Okay. And I know this is, so let me make clear here. The provision that you have I understand it's a portion of the penal code. Can I see the portion that is in our pretrial materials?
It should be in there. Would you like me to pull that up for you?
Yes, or can you direct me to a page in the case file? I have that in front of me.
Ms. Mukavitz, do you have that page number of the code you cited?
I don't know the specific number in the case, but it is page 2 of the pretrial order.
Okay, that'll help. Okay. All right. So, okay, one more time, Ms. Bolter, go ahead. So I have it in front of me. Now, it's your contention that this satisfies Rule 609 as a prior. Go ahead.
Yes, 609A2, as it's a felony charge because it was over $3,000.
Okay. Ms. Mukavitz, response to that?
Your Honor, in her deposition, Ms. Mehta, she stated that this was a Section 496 violation, not that it was anything else. And with the portion of the law that we were given, there is nothing in there that states anything over a certain amount is a felony, simply that crimes of that section of the penal code, Section 496, they are punishable by less than 1 year in prison.
Okay, yeah, so I think that might be the source of the confusion. And maybe Ms. Bolter, you can clarify this. What is your source for stating that an amount in excess of $3,000 constitutes a felony conviction?
Your Honor, subsection 609A2, just the felony charge itself.
Okay, you're talking about the evidence code, right?
Yes, Your Honor.
Okay, so that's the one pertaining to the making of a false statement, right? Not the one that pertains to under 1. Not 609A1, right? Is the one you're referring to, or 609?
Yes, Your Honor. It's 609A1, but it's a false statement. That's a felony.
Okay, so if it involves making a false statement, it can come in regardless of whether it's a felony or a misdemeanor. So I just want to know which route we're going. If it's a felony, but doesn't involve making a false statement, we can go that way. If it involves making a false statement at all, it can come in. So I just wanted to clarify which route you're trying to go down.
I can do your either one, Your Honor. I can do A2, where it's a false statement as it is a crime dealing with theft, the possession of stolen property.
Okay, and what is the act of dishonesty or the making of a false statement in question?
The theft itself, as theft is, it deals with stealing, and it falls under that category of crime of dishonesty and false statement.
Okay, all right. Any further remarks, Ms. Mukavitz? And I can be prepared to roll on this.
Yes, Your Honor, very briefly. The act of theft itself is not a dishonest act. And Ms. Mehta, she actually pled guilty to her crime. She never said that she was innocent when she wasn't. So she never did anything dishonest. And stealing, it's not something that's inherently dishonest. It's not something like fraud or identity theft. She simply stole, and that is substantially more prejudicial than it is probative.
Okay, all right. Thank you, both parties. So I just wanted to clarify this. So let me just lay this out and then we can move on. So I'm going to sustain the objection. I'm going to keep this out on the grounds that under Penal Code 496, based on the facts that we have in front of us and the facts that the court can review in camera, I'm not satisfied that there is any making of a false statement. I don't think, and I think courts agree that theft is not inherently involving an act of dishonesty such as fraud or perjury or making of a false statement in that sense. It's unclear. It doesn't seem like this is a felony. 496 can go use a misdemeanor or a felony. As far as we can tell, it was just a violation of it. We don't know which, and the facts on that are not sufficient to get it in under 609A1. So on that basis, I'm going to sustain the objection. That answer and question, if any was given, will be stricken, and we can move on.
Yes, Your Honor. Ms. Mehta, on March 24th, after you had served all of that alcohol to Jessica Marks, she told you she was driving home that night, right?
Yes, she did. I wanted to make sure Morgan Levin wasn't, so I clarified with them who would be driving.
But that's a yes to my question that Jessica Marks told you she was driving.
Oh, yes, yes, ma'am.
Thank you. I have nothing further.
All right, thank you very much. Any redirect examination?
Yes, Your Honor, very brief.
Go ahead.
Ms. Mehta, Ms. Bolter on cross-examination asked you about how many people were at the restaurant. How many people were at Sunny's Rooftop Bar on March 24th, 2019?
I would say maybe around 20. That's why we only needed 2 servers that night, one to wait the tables and one to make the drinks. There weren't a ton.
And at any given moment, how many people were in the restaurant?
It could vary on a low point in the night, maybe 6 to 10, but it would get closer to 20 at our higher points.
At any point, did you feel like you needed more staff with the amount of people in your restaurant?
No, I've been serving there for a while. I can handle 8 or so groups of people at once.
Thank you, Your Honor. I have no further questions.
All right, thank you. Any recross examination?
No, Your Honor.
All right, thank you very much. Then with that, any further matters from the defense before we proceed to closing arguments?
No, Your Honor. With that, the defense rests its case in chief.
All right, thank you. Let's take a second. Let's get set up for closing arguments. And Ms. Bolter, whenever you're ready, you may proceed.
May it please the court, counsel, members of the jury. Failing to check meant failing to protect. Teenagers act like teenagers. They often make poor choices and they often try to get away with things that they're not supposed to. But the law here in the state of California is written with that in mind. The Dram Shop Act requires that bars be held responsible when they fail to protect minors, even when they try to. My apologies, Your Honor. Can you hear me now? Did I go off the screen?
I cut off too. Did everyone get? Okay, I think
Yes,
everyone
Your Honor.
dropped for a second. We're all back. Okay, I think we're good. It looks
Your
like
Honor, may we request that Ms. Bolter restarts her closing argument?
I was going to recommend the same thing. Yeah, and I think both parties would be amenable to that. Thank you, Ms. Mukavitz. I think that's absolutely appropriate. Let me just make sure here. I'm going to check with our bailiff first. Do we have everyone back? And I think I see both of our judges in the participants list, but I just want to make sure that we're good before we continue.
Yes, I'm checking that now. We have both of our other judges, yes.
Okay, then let's do that. All right, let's recommence closing arguments. Whenever you're
Yes,
ready,
Your
Ms.
Honor.
Bolter.
May it please the court, counsel, members of the jury. Failing to check meant failing to protect. Teenagers act like teenagers. They often make poor choices and they often try to get away with things that they're not supposed to. But the law here in the state of California is written with that in mind. The Dram Shop Act requires that bars be held responsible when they fail to protect minors, even when they try to sneak by. The law requires bars to check IDs. The law requires bars not to serve alcohol to minors. The law requires bar employees to be trained about signs of impairment. And the law holds accountable the bar owners that fail to do what is required. This defendant, Sunny's Rooftop Bar, failed to do what the law required. We heard that it was mandatory for the bar to have a scanner that recognized fake IDs. But we learned today that their scanner was broken on March the 24th. So the next precaution was that the bar owner herself had been trained to spot a fake ID. But all the evidence we've heard today makes it clear that she failed to even check her ID. It doesn't matter if they were too short-staffed or if she was too busy or if she simply didn't care enough. The evidence shows she did not do what she was required to do. Now, I know she sat on the stand today and told you that she must have done it because she always does it. But how do we know that that can't be true? Because when she did finally take the time to look at her ID after that night, she was able to tell within seconds that it was a fake. You heard her say that it was a bad fake at that. Members of the jury, if it was a bad fake days after Jessica Marks died, it was a bad fake on March the 24th. And if she had checked like she was required to do, Jessica Marks would have never been served one drop of alcohol at Sunny's rooftop bar. She wouldn't have had a 0.16 blood alcohol level when she drove to her death. But her failure to check that ID as required was just one way she failed to protect Jessica Marks. Another way she failed to protect her was by serving her a constant stream of alcohol. You saw this receipt. There were over $100 worth of alcohol in less than 3 hours. For a girl as small as Jessica Marks was, any experienced bar owner would have known the effects of that much alcohol. I mean, just look at some of these photographs. Wine, beer, shots of hard liquor. What could this defendant have possibly thought would be any other outcome than obvious intoxication? But did she cut her off? Did she refuse to serve this girl?
Hi everyone, Morgan and I are in Hollywood. We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. You know, I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay.
That slurred speech, that loud talking, those bloodshot eyes, her poor hand-eye coordination, all those signs were the ones this defendant had been trained to notice. You can see that they were present in Jessica Marks that night. And so could this defendant. Members of the jury, in a few moments, this judge is going to tell you that when reaching your verdict, you should use your common sense. Now, you didn't leave your common sense out in the lobby when you entered this courtroom today. And your common sense tells you that the girl we just watched in this video was obviously intoxicated. We didn't have her just sitting inches in front of us to know that. We couldn't smell the alcohol in her. We didn't bring her can after can, bottle after bottle, and we weren't the ones throwing away empty cans when she was done. But this defendant was. That video is what this defendant saw every time she walked up to table 4. Her failing to cut Jessica off, her failing to notice those signs of obvious impairment. More ways she failed to protect her on March the 24th. But what was the final way she failed? It was when she watched her walk out of Sunny's rooftop bar with key in hand. Remember, this defendant had just witnessed Jessica Marks almost fall down the stairs when going to the restroom. And she even made some comments about it. We heard that today, that she said, we may need to cut that one off. But did she? She did nothing at all. She failed to pick up a phone and call an Uber. She failed to take her keys away. She failed to even attempt to protect Jessica from the poor choices she was making as a minor. Those failures let a teenage girl drive to her death. The law requires this bar to be held accountable. They failed to protect under the Dram Shop Act. Now, holding Sunny's rooftop bar responsible won't bring Jessica Marks back, but it is the only verdict here today. We ask that you find this defendant liable for failing to check and failing to protect. Thank you.
Thank you, Ms. Bolter. Closing argument from Ms. Mukavitz.
Yes, Your Honor.
Go ahead whenever you're ready.
May it please the court. Deadly decisions. Now, Ms. Bolter, she just told you that on March 24th, 2019, Sunny's rooftop bar failed to check. She told you that they failed to check her ID, but she didn't tell you about the deadly decisions. She didn't tell you that the deadliest decision made that night was made by Jessica Marks. Now, Miss Marks, her death was a tragedy, and our hearts go out to her mother, Ethel Marks. But members of the jury, you can't simply look at the decisions made by Sunny's rooftop bar. You also have to look at the decisions made by Jessica Marks. Otherwise, you won't see the whole picture and you won't know the whole story. Now, today, the plaintiff had the burden of proving to you by a preponderance of the evidence that Sunny's rooftop bar served Jessica Marks when she was obviously intoxicated and a minor. But today you heard Miss Meadow when she told you that Miss Marks was not visibly intoxicated. And since Miss Marks wasn't visibly intoxicated to anyone working at Sunny's rooftop bar, the only person who could have known how much danger Miss Marks was in when she got behind that wheel was Miss Marks herself. And yet she made the decision to get into her car, to put her keys in the ignition, to turn on the engine, and to pull out of that parking. She made the decision, and she failed to protect herself, which is why I want to introduce you to something called comparative fault. Because if you remember, at the beginning of today's trial, I asked you to consider both the decisions by Jessica Marks and the decisions made by Sunny's rooftop bar. And I asked you to do that even though it was going to be uncomfortable. I asked you to do that because if at the end of today's trial you find that Sunny's rooftop bar bears any of the responsibility for the events of March 24th, 2019, I'm going to ask you to take another look at the decisions made by Jessica Marks. And if you do, and you find that both the decisions made by Sunny's rooftop bar and Jessica Marks were deadly, you're going to be asked for a percentage. You're going to have to ask yourself, how responsible is Sunny's rooftop bar and how responsible is Jessica Marks? So let's talk a little bit more about the decisions that Jessica Marks made. If we start at the beginning of the night, you'll remember that Jessica Marks and Morgan Levin were at an Airbnb. And to get to Sunny's rooftop bar, the two friends drove. Now, you don't normally drive somewhere without the intention of driving back, and you don't normally go to a bar without the intention of drinking. When they eventually got to Sunny's, they got there around 9 p.m. and Sunny Mehta, the owner, was the one to serve them. Miss Mehta interacted with Miss Marks at least 8 times that night, and she told you that Miss Marks was not obviously intoxicated. And remember, in order to open her bar, Miss Marks was mandated by the state of California to take a beverage responsibility course, where she was taught about intoxication and when to stop serving someone who's showing the signs of intoxication. But you heard Miss Mehta when she told you that on March 24th, 2019, Jessica Marks was not showing any of those signs. Now today, the plaintiff, they tried to tell you that Sunny's rooftop bar didn't check Miss Marks's ID. But you'll remember that in 2018, Sunny's rooftop bar agreed to purchase an ID scanner, and they agreed to ID anyone who looked to be younger than 35. You heard that that ID scanner was broken, so Frankfurt Johnson and Sunny Mehta, the two working that night, well, they were checking IDs by hand. And you heard Miss Mehta when she told you that although she doesn't remember, she must have done it because it was policy at her bar. Miss Mehta didn't want to break that plea agreement. But you also heard, you also heard that the defense is claiming that she couldn't have checked the ID because, well, she was shown an ID, and that ID was obviously fake. But today you didn't hear you didn't hear Miss Meta tell you that that specific ID she was shown was the ID that she was given on March 24th, 2019. We don't know the ID that they used. Now, at the end of the night, you heard that Morgan Levin, she didn't want to get back in that car with Jessica Marks. She thought that she looked drunk and she didn't feel safe. So she ordered an Uber. And when that Uber came, she begged Jessica Marks to get into that car. There was an Uber in the parking lot. But Jessica Marks, she made the decision to get into her car. And that decision, members of the jury, that decision, it proved itself deadly because Jessica Marks, she failed to check herself. And in the end, she didn't end up protecting herself. Which is why, members of the jury, I'm asking that you find Sunny's Rooftop Bar not liable. Thank you. And my apologies for the brief interruption for my doorbell.
No problem. Thank you, Ms. Mukavitz. And Ms. Bolter, any rebuttal?
Yes, Your Honor.
All right, go ahead.
May it please the court, counsel, members of the jury. The deadly decisions, failing to check IDs, the deadly decisions, failing to notice signs of obvious intoxication, the deadly decisions, letting her walk out of that bar with key in hand. Those were the deadly decisions this defendant made. That's what cost Jessica Marks her life. Find this defendant liable for it. Thank you.
Thank you very much, Ms. Bolter. All right, the matter is submitted. Great job, everyone. Give us just a couple minutes so we can finish filling out our comment sheets and our ballots, and then we'll come back when we're all done and we can give some brief comments.